All right, good afternoon. Welcome to Hands On. My name is Alana from the Innovation Cluster. And for those of you who aren't familiar with the Innovation Cluster, we are a not-for-profit organization that supports startups working in innovation. We do so by offering advisory services, access to partners, and workshops such as this one. If you do have an innovative idea or a startup working in technology, we do encourage you to apply at www.innovationcluster.ca. Again, welcome to Hands On, preparing and filing provisional patent application with Prima IP. There will be time at the end for a Q&A. You can populate the chat with some of your questions. So some of the learning objectives today are an introduction and a step-by-step guide on patent application process. So today we have Marcelo Sarkis of Prima IP. Marcelo founded Prima IP having practiced 26 years at a leading intellectual property boutique firm and an internationally renowned multidisciplinary law firm. Marcelo has an extensive experience in the drafting and prosecution of patent applications and industrial designs in the pharmaceutical, chemical, oil and gas, medical device, and mechanical areas, and has advised clients on the attainment, management, and assessment of intellectual property rights. In his free time, Marcelo enjoys teaching and training Taekwondo at Blue Wave Taekwondo Canada, as well as being a board member on the New Canadian Centre in Peterborough, Ontario. So please give Marcelo a warm welcome, and he's going to get started.
Thanks, Alana, and thanks, everyone. Everyone can hear me okay? Thumbs up? Okay, perfect. Thanks, everyone. This is going to be a pretty full session, so what I would like to do is make sure everyone has a pencil and paper handy, or a writing instrument, and some paper or a screen handy. There's going to be some work to do later on in the workshop. So today we're going to talk briefly about drafting a provisional patent application and touch upon some of the requirements for filing a provisional patent application with the United States Patent and Trademark Office. This is a disclaimer. The presentation is provided as information only, not intended as substitute for intellectual property advice. You should always consult with your patent professional with your specific questions or concerns. Every situation has to be assessed based on the facts at hand. As I said, we're going to talk about drafting a provisional patent application and some of the requirements, or all of the requirements, for getting a filing date for filing a provisional patent application. What is a provisional patent? First of all, there is no such thing as a provisional patent. The only thing that exists is a provisional patent application. You file a provisional patent application in the US. As I said, it never issues to patent. It's never examined. It's never published. But what it does is it gets your foot in the door. Sooner, the first to file will be the first to grant a patent. So if you're disclosing your invention at a trade show or at a conference, or you're presenting a webinar, what you should do before any public disclosure is file your provisional patent application. That helps mitigate any ramifications of a public disclosure before a formal patent application is filed. If you take no action with your provisional patent application within the 12-month period, your provisional patent application will become abandoned. It will never publish. As I said, it'll never be examined. It'll never grant. The only thing you will have is a one-page or perhaps 2 pages from the United States Patent and Trademark Office indicating that they received your money. Thank you very much. And there's a receipt for filing your provisional patent application. Parts of a patent application include a cover page, an abstract, a background. Background usually discusses the prior art, what has been done before. Summary, which is a summary of your invention. Specification, which includes the detailed description of your invention. Drawings to support your invention, and the claims. Claims are what define your property, your intellectual property. When you file a provisional patent application, the minimum requirements to get that filing date is you need a title. You need to list all the inventors. You need to identify the addresses of all the inventors. You need to provide a correspondence address. You need to provide attorney's information. You need to have a detailed written description, which, as I discussed above, includes a background, summary, and drawings. You don't need a claim in a provisional patent application. That's not required, but we strongly recommend that claims be filed. Because in some jurisdictions, if the priority application does not include a claim, there will be issues down the road when you're looking to claim priority. For example, if you go into Europe or in the UK, they're going to say, well, what did you claim when you filed early on? Is there a claim? So we always file our provisional applications with a claim. And of course, the United States Patent and Trademark Office will want their fees. When you're drafting a basic provisional patent application, it's always ideal to have a IP or patent professional prepare the application. And the reason being, it's going to be used as a priority document in preparing a formal patent application. And in many instances, formal patent applications have been invalidated in the courts because the provisional patent application did not support the filing date of the formal patent application at the end of the day. So it's very important to at least engage with an IP professional and have him or her review your provisional application and provide you with some recommendations and or suggestions. What is important in a provisional patent application is that you also provide a disclosure that is detailed enough that it will enable a person of ordinary skill in your industry, in your sector, with all the information in the patent, such that they will be able to replicate your invention that you have claimed without undue experimentation. So it's important to provide enough detail. A patent is a double-edged sword. You're going to get a 20-year monopoly, but in exchange for that, you need to provide enough information to allow someone in the field to replicate without undue experimentation. And the reason being, the patent system was created not only to reward inventors for innovations, but it was also created to allow for the propagation of information and technology to further advance our lives, to better our lives. And the only way to do that is if a competitor down the way is working on a similar field as you, in order for that competitor to improve on technology to further better our lives, they need to have a document that provides clear description of your invention. A third reason for that clear description is if somebody is trying to replicate, they need to have that information. Or if somebody's trying to design around your claim, or they're trying to determine, do I infringe or will I infringe this patent or not? If there isn't enough information, they may not be able to answer that question. And if that question is not, one can't answer that question, then there's a defect in the patent. Even though I just said you need to have detailed information in your application, what you also want to have in your provisional, which will then become a formal application, is enough variants or enough alternatives in your invention or your application to encompass alternatives and or variants that others may use. So if you say that I'm going to fasten the two members with a helical fastener or a screw, and that's all you talk about, well, can it be done by gluing the two members together? Can it be done by hammering the two members together? Can it be done by another means of fastening the two members together? So you should always be thinking about not only your invention, but always think about, if I'm a competitor, how could I design around my invention. So it's important to have those variants, those alternatives. And it's important to have clear drawings in order to assist the reader when they're reading the patent application or the patent to better understand the invention. And in many instances, the drawings may be the last resort. There may be something shown in the drawings that you can then hang your hat on at the end of the day to say, this is what differentiates my invention from perhaps prior art that the patent office is citing during the examination of your invention. When you draft the claims, you want to identify the essence of your invention. Bring it right down to basics. What is it? What does it do? And how does it do it? Again, when you're looking at the claims, think about variants to achieve similar results. Can you claim a subcomponent separate from the overall invention? Maybe you have a widget for a system, but that widget is new as well, and that widget can be used in other systems. So now you essentially you have two potential patents at the end of the day. So you may want to divide out your invention to subcomponents. Can you claim the use of your system, a method of manufacturing your system? What we do with claims, you start very broad with a very broad umbrella to capture as broad as possible what you believe is your invention with just enough differentiation to differentiate from the prior art. As you draft your claims, you can go and further narrow the claim. So for example, I talked about the helical fastener or a screw. What you could do in your first claim is just say a fastener. And then a subclaim could be wherein the fastener is a nail. And another subclaim could be wherein the fastener is a helical fastener. Another subclaim could be wherein the fastener is a glue. When you draft the summary should reflect the claims. And remember, the claims are what define the fence around your intellectual property. And just like the claims started broad and ended narrowly, you want your summary to start broad and end narrow. So here, just an example from the chemistry world, we say, in one embodiment, the pH adjuster is an acid. We started broad, we would say we have a pH adjuster in our system. And then we get a little more narrow, we say the pH adjuster is an acid, depending on the environment. In another embodiment, the pH adjuster could be a base, again, depending on our environment. And perhaps in another embodiment, the pH adjuster could be a combination of an acid and a base. Identify your variants in your summary. And what's important to do is use the word may instead of will. Because if you're not 100% sure that, let's say, this pH adjuster will always adjust the pH to neutral, a safe way to say it is it may adjust the pH to neutral. Therefore, you're not really committing yourself 100%. Because there could always be an argument if the patent is ever litigated that someone is hired to do an experiment and they carry out the experiment and the pH adjuster doesn't adjust for some reason. We don't know. When you talk about the detailed description and drafting the detailed description, the detailed description further supports the claims of your invention. But now you're getting into absolute specifics. If you use the screw in the example, you're going to say the fastener being a screw in this example. Don't be broad and say where it is a fastener, because now we're getting into specific examples. You can say, in this example, I used a screw, but other fasteners could be used. but identify exactly what you're doing in your example. The more examples, the better as well. If you have examples with varying conditions, so a screw, a nail, glue, always try to put in as many examples as possible, because that further supports an attack on your patent that you have not provided an enabling disclosure, where you can say, I provided 10 examples here, they've all worked. So definitely anyone could follow those examples and replicate my invention. And now, and as I said, in the examples, you are now definitive, right? It can be seen a screw was used in this example. Drawings should always be clear and specific, and you can refer again to the drawings in the detailed description. Black and white drawings are the most preferred because they are the drawings that are received around the world without any issue. Some patent offices will accept colored drawings, but some won't. So it's always preferred to use black and white drawings if you need drawings. In some cases, you may not need a drawing for a patent application. But most patent applications, utility patent applications, should have drawings. Because as I said a few slides back, if you run into a situation where perhaps it's not clearly described in the description in terms of words, but it can clearly be seen in the drawing. And that may be the only thing that you have to hang your hat on at the end of the day if the examiner starts throwing a lot of prior art against your invention, saying, there's nothing new here, I can't give you the claim that you want. And perhaps we're trying to get a broad claim. Nothing wrong with that. I'd rather fight for a broad claim and get something a little narrow than file a very narrow claim and get a notice of allowance right away. My client may be happy, but that claim may be so narrow that it may not result in some commercial advantage. What you want is a commercial advantage. You want a claim broad enough that it's going to mitigate your competitors coming into and competing with you. So here are some of the steps in drafting a provisional patent application. And all of this you can do before you meet with a patent professional. It will definitely help the patent professional better understand your invention, and it's going to help you as well understand the process and the mechanics to properly have a patent application prepared. First thing you want to do is just describe your invention on paper or on a computer, something that you can share with your patent professional. Hand sketches are fine. You don't need to go to a high-end draftsperson or an engineering firm to get engineered drawings at the onset. That's not required. Hand sketches are fine at the onset. And then ask yourself, well, what is it? What have I invented? What does it do? And how does it do what it does? That's important. And then remember, again, think about, can it be done in a different manner than you've come up with? So you may come up with a method of making a cup of tea, right? Where the method comprises inserting the tea bag in a cup, pouring hot water in the cup, allowing the tea to steep for 3 minutes, add milk, and add sugar. That's your claim. Let's just say. So then what happens with the individual who doesn't insert a tea bag but inserts loose leaf tea? So you have to think about these things. What happens to the individual who doesn't like tea in their, or doesn't like milk, sorry, in their tea, right? Or doesn't like sugar in their tea. They prefer black tea. So these are things that you should think about when you're speaking with or preparing to speak with a patent professional, or if you're drafting your own provisional. The second step is to describe the essential elements of your invention. So we talked about preparing a cup of tea. What are the essential elements? What is absolutely necessary to prepare a cup of tea? Tea into a cup, pour water in the cup. I think that's it. That's the essential. Doesn't have to be hot tea. Doesn't have to be hot water. Some people may like very weak tea. It's not in a bag. It could be loose leaf tea. So now you figure out what you decide. What is the essential to your invention, such that if anybody were to carry out the minimum steps or have the minimum number of elements in their system, they would still infringe your claim. And then what are the non-essentials? And you can list the non-essentials as subclaims. Once you've got to that point and you've drafted a preliminary description, read back or have someone read back what you have just described. Or you can read it to someone who's under an NDA and have them draw out what you've described. I guarantee if you have 10 people in a room, and I've done this before, and I read something, describe something, I'll get 10 different drawings. Everyone is going to interpret that language differently. So what you want to be able to understand is, and convey, is that they have captured at least the essential element of your invention. And as I said before, always include variants in your description. It's important. Now we get into setting examples. So you should set out at least one working example, such that a person having ordinary skill in the field. Now, the definition of a person having ordinary skill, this person is a mythical creature. This person does not exist. It's a person that was created by the law, by the courts. But it's such that it's a person who is able to understand the technology, but has no inventive ingenuity. So if that person is reading the example and carries out the instructions, word for word, no inventive ingenuity, if they get to the solution, the result that you've claimed, then you've done your job. But if they're scratching their head and saying, well, it says to add water, but it doesn't tell me how much water to add, or it doesn't tell me what temperature, or if it said hot water, well, what does that mean? 25 degrees Celsius? Maybe it's 20 degrees Celsius because the room you're in is 5 degrees Celsius. So it can be relative to the environment that you're in. So you want to be able to describe the possibilities in your patent application so it covers off any undue experimentation or ambiguity. So then the fourth step is you want to define the boundary around your IP. What did you invent? So you describe something, but what really have you invented? Maybe you invented something broader than what you've actually come up with. And that would be something that you would work with your patent agent to define. So for example, when we talked about you've invented a system, a brand new system for, I don't know, opening canned goods. But there's a widget in there in that system that can be used for other pieces of equipment because that widget has a very unique role to play in a mechanical device. So that's important as well. And always make sure you have support for what you're claiming as your invention. And that is, do you have an enabling disclosure? Have you described your invention well enough that anyone in the field of in your sector, your industry, picking up that patent application will be able to read it, understand it, and replicate your invention without undue experimentation. Here's the working example for today. Since we're living in the world of masks, let's just use this example. Okay, So everyone got this picture in their mind. Remember, what is it? So this is your opportunity to write down what you think it is that we just saw there, right? Here it is again. Okay. What is it? What are the components that make up what it is? How are the components related to each other? What is the unique element of your invention over what others have done? I would guess here, at least from first blush, the unique component is there's this transparent area on the mask. When you draft a claim, you always have to have certain elements in the claim. This is to meet the requirements of patent offices around the world. You first need an introductory phrase or a preamble. And that's basically you want to describe, first of all, what is it? So here it could be a mask, or is it a nose and mouth mask? I don't know, right? It really depends on what the prior art is, depends on what you believe you've invented. Or is it a face mask, right? The next step would be a transitionary phrase. So a transitionary phrase is now you're going to lay out all the elements or the essential elements of your invention. So if you say a mask, and now you use the transitionary phrase comprising, it means a mask having at least any of the following elements that you're going to list. So if you say a mask and it has 3 elements or 3 components, anyone who makes a mask with at least 3 of the components that you claimed would infringe on your claim. They could have 10 components, but if they have those 3, they would fall within your claim, your invention. Whereas the consisting of phrase would mean exactly what you're saying, a mask having the 3 elements or 3 components. So comprising and consisting of it very strong when drafting patent claims and can be very detrimental. It can be very broad or it can be very limiting. So now the individual who has 10 elements and they only have, and you only said consisting of 3, but they've got 10, and the additional 7 is adding to the invention, they can argue, well, I'm not infringing on your claim because I've done more than what you claimed. Whereas comprising, they may have a hard time arguing non-infringement if they have the 3 elements that you laid out in your claim. And that's what we talk about. We talk about claim limitations. So whenever you add a new element or a claim limitation in the claim, you need to start it off and introduce it with the article a or an. So we could say a mask having a first covering. And then you say we're in the first covering or when said first covering when you refer to it a second time. That's important. It's just clear for the patent office to understand if you're referring to the same covering or if you're referring to another covering. Because you could say a first covering and then a second covering. And then when you talk about a covering further on down your claim, the patent office or the reader may say, well, are you referring to the first covering or the second covering? So by introducing it with the article a or an in the first instance, and then referring it to the or said in other instances, it further clarifies the claim. I have many clients who say, I don't understand the language in a patent claim. It's patentees, it's our own language, but there's a purpose for that language. And actually, it's very clear when used correctly. So here's, hopefully you've been, thinking about this and writing some things down. So here's what I sort of put together. Okay. Now you can see the picture in the upper right-hand corner is not the same as the picture that I showed you at the onset. But then you can start drafting a claim, for example, a mouth and nose mask, comprising a covering to cover said mouth and nose of a user. Said covering comprising a transparent mouth portion and a translucent portion surrounding the perimeter of the transparent mouth portion. And then a fastener for securing said mouth and nose mask to a user. So that there is pretty broad. It does define where the transparent portion is. It's around the mouth, because if you remember when we saw the slide before, it only showed the mouth. It didn't show the nose. So this guy's mask that he's wearing here, the entire face is covered. When we talk about a mouth and nose mask, but here it covers the eyes, the nose, and the mouth. And the eyes, nose, and mouth are clear or can be seen through the mask. So that mask would not be covered by this claim. And now when we talk about a dependent claim, where you further narrow the claim, you can say the mouth and nose mask of claim 1, wherein the fastener comprises an elastic cord fitting over an ear of the user. We talked about a fastener in the first instance. We don't say what it is. Just any fastener will do. It could be glue for that matter, or Velcro, or whatever, but we just say a fastener. The next claim, we define the fastener as an elastic cord fitting over an ear of the user. The third claim, we talk about the covering comprising a nose seal portion, forming a seal around the upper portion of the user's nose. So, some of the masks come with that metal insert around the nose to allow for a better seal around the nose. We can add that. We could also add another claim to say where the fastener comprises a cord, a non-elastic cord, just a cord. Because if you see the old traditional ones, they're just a cord and then you tie a knot on the back. Still a fastener, right? So that's the first step you do. You draft the claim. When you draft the claim, you get an idea of, and again, it's just the first draft. You get an idea of how you want to define the fence around your intellectual property. And now we talk about the prior art or the background. What are the current masks in the industry that we're aware of? What are the problems associated with the masks? So here we can say current masks cover the mouth of the user such that the mouth of the user is not visible. So that's the problem. And this may result in individuals not understanding the user when speaking, as individuals are not able to see the movements of the mouth to assist in clarifying the user's words. Again, a problem. So we can say there's a need for a face mask that allows the user's mouth to be seen while being covered by a mask. So there's a solution there. Now, the Batman mask covers the nose, but it doesn't cover the mouth. So it wouldn't apply here. Once you've drafted the background, laying out the problems and this proposed solution, you now draft the summary. Now, remember I said the summary reflects the language of the claims. So the claims start broad and they end up narrow. Same thing with the summary. Overview of the invention in general terms, a face mask, start broad, and then get into further detail, further defining the general terms throughout the summary, where the face mask covers the nose and mouth of the user, wherein the mouth portion is clear or transparent. And in the summary, as we discussed before, that's where you also want to include alternatives or variants. So for example, we talk about a fastener in the first instance. The fastener may be elasticized or non-elasticized, right? The fastener may be such that you may actually have this metal nose portion extend throughout the entire length of the mask, such that when you do this, perhaps the metal within the mask will keep your mask on, so there's no need for loops around your ears or to tie the mask behind you. Or maybe you come up with something that allows the mask to be secured onto your face through your glasses, if you wear glasses, right? You need to think how a competitor would think to try to get around your invention. You then have drawings. Remember, we said it helps the reader understand your invention. But in the first instance, you want to draft a brief description of your figures or of the drawings. And you include different views and different variants. And the brief description is very simple. Figure 1 is a top view or a front view of the face mask according to one alternative. Remember, we talked about alternatives. So in one figure, you may not be able to show multiple alternatives. And so you clarify that figure 1 is a view of the mask in one alternative. Figure 2 could be the mask in a second or another alternative. Now you draft the detailed description. Here, again, you get into your alternatives, but you can refer now to your figures. So figure 1 is a front view of the mask according to one alternative, but now you're going to go into detail. And you can see in the drawing in the upper right-hand corner there, all the elements or components of the mask are enumerated. So there's a numeral reference to each component. And that's how you get into describing your invention. So for example, you say, referring now to figure 1, there's depicted a face mask 10 with a transparent portion 20, covering the mouth of a user, and a non-transparent portion 30, situated around the perimeter of the transparent portion 20. The face masks include an elastic loop cord 40 on either side of the face mask, each loop cord 40 for securing around the ear 50 of a user. And here you can talk about variants as well. You can say, although the fastener is described as an elastic loop cord 40, it may be a non-elastic cord on either side of the face mask 10, which may be tied around the back of the head of the user. Now, what's interesting, the US is one jurisdiction where if anything that you're claiming as part of your invention, as part of the claim language, remember that defines the fence around your intellectual property, it has to be in the drawings. Has to be in the drawings. So in some cases, you can include a drawing that are just box diagrams, which just shows all the components. It may not be realistic, but it shows all the components. It could be a schematic. And you can say, I described it in the figures. It's here. So that's important for you to also when you're working with your IP professional, or if you're filing provisional on your own to make sure that your drawings are complete as possible. Now we get into some of the mechanics or the requirements in filing your provisional patent application. We like to file a provisional patent application with the United States Patent and Trademark Office. The reason being, if nothing is done with it within the year, as you now know, it goes abandoned. It dies before the U.S. Patent Office. If we were to file an informal patent application in Canada, it'll be published 18 months from filing, unless you request withdrawal of your provisional patent, of your informal patent application with the Canadian Intellectual Property Office. The U.S. provisional patent application is recognized globally as a priority document, and importantly recognized as a priority document for international or PCT applications. The government filing fees are $300 if you're a large entity, meaning who is the applicant filing. If you have 500 or more employees, you're considered a large entity. It's $150 for a small entity, less than 500 employees, or a university or a nonprofit organization, individual inventor, or small business concern. The U.S. Patent and Trademark Office also has an entity level defined as a micro entity. And that's usually an inventor, individual inventor. You pay $75 for filing. That's the government filing fee. And you're allowed to do that. There are some certain restrictions based on your income, your annual income. There's a form that you need to fill out. And as long as you don't have more than 4 previously filed patent applications with the USPTO identifying you as an inventor, then you can file as a micro entity. I would encourage you to verify the fees and definitions on the USPTO website, because it may change. It's typically changes on an annual basis. What I'm going to do now is I'm going to show a short video on from the USPTO on filing your U.S. provisional application. So if you just bear with me. Yeah, I was having some sound issues, remember, this morning, so I don't think we'll be able to get the sound, unfortunately. But you can see, I can send a link to everyone after the presentation. There is the wording underneath as well. It's captioned throughout the presentation, but we don't need to look at the video. I apologize for that. So that's the essence. That's the essence of the presentation. The video would have just gone over some of the mechanisms in filing, but again, I can share that with you after the presentation, but I'm happy to take some questions at this point. I wanted us to all draw and show our face masks, but it works better when we're in person.
Okay, so it looks like we already have one question in the chat. So if anybody does have any questions, you can send it into the chat, or even if you want to try to unmute yourself, that works too. So the first question is, if somebody could show that the patented idea did not work, but their version did work, could the patent be superseded? For example, if I could show that a mask using a special non-transparent material did not fog up, while the patented design did, could I get a separate patent approved?
Well, it's a good question. What you're trying to prove is the prior art is non-enabling. So if a prior art reference is cited as against your invention, and the examiner says it would be expected that the prior art would function as you are describing, the burden then goes to the inventor to provide a declaration with experimental data to prove the examiner is incorrect.
Okay, I have another question. Does patent applicable Or is a patent applicable to software or software specification or a piece of logic or code?
So most software programs, we discussed this in previous workshops. The code itself is covered by copyright. It's a literary work, but the logic that the software is carrying out, if the logic is new, then you can claim the steps or the method in a patent application, as long as you can show that it's new, inventive, and useful. And for many software applications, you need to have a hardware component in it as well. That's what the current, at least with the the Canadian Patent Office requirements are. But it's the landscape for software is changing constantly. So that's something that you need to speak with your patent professional to make sure that you're getting the most up-to-date information. A very good question.
Okay, that kind of answers Jeff's question. What generally is patentable? How unique or new does it need to be?
So the three tests, it has to be new, meaning it has never been done before. That's the first question. First requirement, I should say. It has to be inventive, meaning it cannot be obvious. It can't be considered obvious to a person of ordinary skill. So remember, we talked about our first example where you are fastening two members with a helical fastener or a screw. And the prior art showed fastening it with a nail. The question then becomes, would it be obvious that the two members would be secured for a longer period of time, fastening the two members with a screw versus a nail? And that's a question that would be answered by the person of ordinary skill in the art. And in this case, in some instances, you would need to provide, again, a declaration or an affidavit with some testing to show that it's not obvious, that actually it took much more work to be able to combine or fasten two members with a screw versus a nail. And maybe it means that when you use a screw, because the members are so tightly secured one on the other, you know, the surface of each one, the surface area of each one is touching, that it prevents oxidation. I don't know, I'm just making it up. So if you can show some unexpected benefit that was not appreciated by the prior art, that's also a defense. And the third requirement, it has to be useful. So to answer your question, there are three requirements. It has to be new. No one has ever done it before. Has to be inventive. It can't be obvious. There must be some inventive ingenuity or unexpected benefit, and it has to be useful.
Okay, before I read the next two questions, I'm just going to remind everybody that Marcel's past workshop going over more of an intro to IP is available. So you can get that link through the Eventbrite page that you registered for this workshop. The link is on that page. This is also recorded, so you guys can refer back to it. Okay, so the next question, what is the most common mistake that occurs when individuals file provisionals without a patent agent's participation?
Very good. The applications are very narrow. They're not concise in description. I've seen provisional applications filed in some cases 2 or 3 pages long with a couple of hand sketches. And now if you're going to rely on that description to then file a formal application, it's going to be very difficult. And I've had to tell clients, there's nothing I can do for you here because it's too late. You took the step of filing a provisional and now you filed a formal international application, and now it's being examined and you didn't modify or amend the application before filing it internationally or even domestically, that the patent office is saying, I don't know what I have here. I don't understand it. And you haven't conveyed enough such that a person of ordinary skill picking up the application can read, understand, and replicate the invention without undue experimentation. So many times people who file applications on their own are filing too early. They have an idea, they have a concept, but they don't know how to put it together. You need to have at least one example to show how am I going to make this invention? You can't patent an idea. So that's the most common mistake. The other common mistake, as I said, is being very narrow. So you came in and you said you filed for a screw to fasten 2 members. That's all you say. Your patent goes through. Somebody down the street now uses glue or uses a nail, and they're competing with you side by side, and you try to sue them for infringement, and then the courts say, all you said was screw. You didn't say, or alternatives, here are some alternates, a nail, glue, etc. You didn't include any variants, and that becomes quite problematic because you haven't included your alternatives.
Okay. The next question is from Paul. Before starting the application, what is the best way to search prior art in the area of your invention?
You can search prior art in any search engine that you're comfortable with. I would recommend the publicly available patent databases. I would recommend any databases that are relevant to your specific industry that may not necessarily be covered in the patent databases. I wouldn't always think about just searching Google Patents, because I know, oh, I did a search on Google Patents. Google Patents are not complete in terms of a record. And I've had one client where he tried to search his own patent on Google Patent and he couldn't find it. But I knew it existed. He knew it existed. But he searched using a word term that's in the patent. But what Google did is it recognized, it thought that the inventor typed the word in incorrectly, misspelled it, and searched a different word rather than the word that he's looking for. And you could never find that reference. So the indexing is an issue. All I'm saying is don't just rely on Google Patents. There are other databases that are publicly available at no cost, the U.S. Patent Database, the World Intellectual Property Office Publication Database, the European database, the Canadian database.
Okay. The next question is from Robin. This might be the last one, just so people can grab a bite to eat or get back to work. Okay, so once you have a utility patent, do you recommend continuing to file design patents for products created specifically for this manufacturing tech that is covered? For startups, we often don't have the money to enforce patents, so could money be better invested in establishing a brand identity and capturing market share?
Well, I mean, brand identity and capturing market share is a business decision that you have to make. A patent and an industrial design are insurance policies, such that if someone infringes on your IP, then you can enforce your IP. If that's not an issue, then you may not need to secure your IP. Many clients, what they'll do is they're going to go in, make their product, flood the market, make their money in 3 or 4 years, and then go on and do something else. They don't care about the competitors, right? They don't care about that. So it's a decision that you have to make. But your first part of your question, if you have a utility patent, which is the U.S. term, and you're looking for a design patent, which is a U.S. term, in Canada it's an industrial design, you have to think about the timing. Timing is very critical. We talked about this in my previous presentation as well. You need to file your patent applications before any public disclosure. Okay, if you're looking to file internationally, Canada and US have a 1-year grace period. So if you were to disclose today, you have 1 year to file your patent application in Canada and the US and some other jurisdictions as well, such that your disclosure won't bar you from obtaining a patent. But if somebody else discloses, you have to worry about that. So we always take a belt and suspenders approach in that you should file your patent application before any public disclosure.
Okay, perfect. Thanks. Okay, so I'm going to start wrapping up now. I want to thank everybody for attending today. A reminder again that resources are available to you via the registration page, and this one is also going to be available to you as well. Thank you so much, Marcelo, for taking the time.
Thank you, and thank you for your patience. We had some technical difficulties today, and you can see it was still, Murphy was still rearing its ugly head with my sound on the video. I will send that link to Alana as soon as we get off the call, and she can share it with you either through the cluster website or through your mailing list. But thanks again, everyone.
Yeah, thank you so much, everybody. If you do want to get in touch with Marcelo, you can send me an email and I can connect you. And again, I'll be sending all this information out to you. So enjoy the rest of your day and the rest of the week, and we will see you again later.